translator signs it, and then I sign it, saying I transcribed as they were interpreting. So, you know, that's the technique I've used, which has been successful so far. But you just have to keep in mind that it can take a long time to do that. It's not just having someone writing their affidavit and then you submit it. These applications have, so if I'm representing someone, keep in mind that these applications are online for people to be able to access on their own. You don't have to be an attorney or have an attorney to fill out a visa application and send it in. I think it's helpful, and I want to be available to help as many people as I can who are domestic and sexual violence victims to put their applications together, but you don't have to be an attorney to do that. If you do have a representative helping you put that application together, that form on uscis.gov is called the G28. It's like a 2-page document that says, I, client, allow Ms. Barkey, my attorney, to correspond on my behalf. So it's kind of like a cover letter of her giving me authority to act on her behalf. But what else does that do? If this cover letter is with, it's the part of the federal government, United States Citizenship and Immigration Services, what does that do if everything's coming to my office as opposed to her address?
Keeps her whereabouts confidential.
Exactly. It keeps her whereabouts and what she's up to, that there's this thing from some United States office coming to the house, confidential. All of these applications for our clients would go to the Vermont Service Center office of the United States Citizenship and Immigration Services. That office handles all the DV-SB applications. And those workers, those federal employees, are trained, as I was trained, on the dynamics of domestic violence, etc. They understand how, how the circumstances of even applying for something like this might put someone in danger. So they keep the information confidential from everyone, even their own sister ICE agency, law enforcement, their own sister law enforcement agency. So people always ask me, am I going to bring my attention to the fact that I'm undocumented by applying for this visa? What I say to them is, one, the Vermont Service Center office is going to keep your information confidential. You can't even get information about that case unless you have a receipt number and unless you have a G28 on file. So you can't get that information. It won't be shared with anyone unless you're, usually you're corresponding by mail or email. Anyway, that's one thing. And the other thing I say is, if you apply and are denied, that's another concern people have. What if I'm denied? Is that going to immediately trigger deportation proceedings against me? No. It goes, again, even that information is kept confidential and kept separate from law enforcement agencies. So, in the greater scheme of the priorities that ICE and the federal government has, the priorities that they have regarding who to prosecute, given limited resources, who to prosecute for deportation, domestic and sexual violence victims with denied U visas or denied VAWA self-petitions are at the bottom of the list. And even those who are denied, by the way, you can apply again. There's no bar to applying again. Maybe you did it on your own the first time and didn't do a good job of putting all the information together for all of the elements that we're going to go over, and now you have help. So, for example, when I started my job, I inherited a case that had been denied. The attorney who handled that case applied again. She was approved, and then I did her green card application. So now she has a green card and she's all set. Lawful permanent residence.
How long
start these when there is a case pending?
Good question. Thank you. And when I talk about U visas, I was going to talk about that, but I don't. I do not start them until the case is over. Especially with the U visa, because the U visa requires certification from either the Commonwealth's attorney or law enforcement that the person was helpful in the investigation or prosecution of the crime. So how I handle it is I don't do anything for the client until the case is over. That way, she doesn't have a pending visa application while her case is pending. And that can't be used to impeach her or impair her credibility.
So how do you get to say that she is the victim of domestic violence or sexual assault if the case is already concluded? Does that not hinder you in some way?
Why would that hinder me?
Because
just because a case is
done.
concluded doesn't mean she's no longer a domestic or sexual violence victim. In fact, especially if there's a conviction, and you don't need a conviction to get these types of visa applications. I'll get into more of the elements. Just because even if someone was never, if there was never a criminal case, there are other ways to prove that someone is a victim of domestic or sexual violence. Her own affidavit, protective orders, affidavits from working with social workers or advocates, But with the criminal cases, after the criminal case is over, that doesn't necessarily mean the domestic and sexual violence is over. In fact, sometimes it could actually make it worse.
Well, I was just thinking that the criminal case pending is a big step towards proving your case.
Yes.
And a conviction would be great.
Right.
But if you don't start the process until it's all over, is there any danger? And is this based on danger or what?
No, it's not. I'll get more, those are excellent points, and I'll get more into the details of it when I describe the elements you need to prove to get these visas. But, sort of the general response is that there are many ways to prove that you're a domestic or sexual violence victim. And for purposes of these visas, you'll see the nuances when I get into the elements. Okay. All right, so moving on. So volatile petitions and battered spouse waivers. So this is on your slide 11. This is what a person would need to prove in order to get an approved VAWA self-petition, that's a visa. They have to prove that their own identity, that's where the birth certificates come into play. Evidence, this is the key element, number 2, the key element of the VAWA self-petition. Evidence of the abuser's legal status. Your abuser has to be your U.S. citizen spouse or green card holding spouse. If you are married, but your husband or your abuser, and it doesn't matter what the gender is, by the way, just because it's called Violence Against Women Act, doesn't mean that men don't qualify as petitioners as well. So if I have a victim who's undocumented and she's married to someone who is also undocumented, or it has a visa but he doesn't have a green card, the lawful permanent resident status, she cannot fill out this VAWA self-petition. She is not eligible to fill out the VAWA self-petition. You have to be married to a U.S. citizen abuser or green card holding abuser. And that marriage has to be in good faith, okay? And I have noticed in my experience of doing these applications over the past 4 years, there has been a much higher level of scrutiny of some of these elements, including good faith marriage. So it used to be, at least this is my anecdotal experience, that the marriage certificate was enough to prove good faith marriage. Now that's clearly not enough. The petitioner has to show in her affidavit and other elements of her visa application that this was indeed a good faith marriage. And I'll tell you, so far, since I've been doing these, I've only had one. Now, they can ask for more evidence, and you end up, that delays the process. They ask for more evidence, and then you hand it in, and they review it. But I have had basically a total success rate except for one case, and I'm right now in the process of asking them to reconsider and, giving them additional evidence to reopen their decision and review again. And that was a case where when I met this client, I said from the outset, we're gonna have trouble proving good faith marriage. I believe her from everything that I've heard from her and from the advocates who've worked with her, the affidavits from neighbors and people from the church and et cetera. I believe that she truly is a domestic and sexual violence victim at the hands of her husband, but she married him and they only lived together for 4 months before she left. So, while that doesn't necessarily, mean she's not a domestic violence victim, it does mean we have a problem in proving good faith marriage. The other part of her particular problem, sometimes you can prove good faith marriage by the birth of children and the child's birth certificate having the father's name on it. Because she was scared and she was fleeing just after 4 months of marriage and she was pregnant, she was fleeing somewhere where he didn't know where she was. She didn't want to put his name on the birth certificate and risk that involving him and helping him find her. So that's the argument we're trying to make. I mean, honestly, I don't know if it's going to be successful. I think it's been, and as I said, from the outset, I told her, that's a weak part of your case. So she may be a domestic violence victim, but based on proving these elements, I don't know that she's going to be able to get this visa. Yeah, so that's one element, and then shared residence with this particular client, that was another problem. They were only together for 4 months, and he didn't put her name on the lease. She's not on anything. The only way we were to prove that they lived together was her own statement of that, and I think there was something to one of her children, so her husband's stepchild, something from the school that had the address that they both listed as their own address, but never together. Their two names were never together on any document with this address on it. So it's affidavits. It's not, to me, it's not the best evidence. The thing that's different that you have to get your head around with the visa applications is that it's any credible evidence. That's the standard, any credible evidence. It's not, by a preponderance of the evidence or beyond a reasonable doubt. It's any credible evidence. So that could be a lot of things, but I would say, an actual lease with both of your names on it and the address is going to be considered more credible than your own statement or the statement of your sister that you live together, right? So we'll have to see in that case how this works. So shared residence is one of the elements you have to prove. Evidence of the physical, mental, and or sexual abuse. In this visa application, you don't have to prove any cooperation with law enforcement or prosecution. There doesn't have to be a criminal case involved. There doesn't have to be any case involved with this type of visa application. So a person could potentially not have anything to do with the criminal justice system as a victim of these types of crimes, but still get a Volatile petition. So
How do you prove it if you don't have?
we're going to get
Trying
into
to keep it quiet.
Yeah, I know. We're going to get into the details of that in a minute, so hold that question. You also have to prove your good moral character and evidence of extreme hardship if you had to go back to your home country. So, how do you prove these things? Again, the any credible evidence standard. So for identity, passport, driver's license, from these, birth certificate, from abuser's legal status, a copy of their social security card, for example, or their green card. Now, one of the successful cases I had, this was a lady, it was really interesting in how these cases work. I never met her. We did everything by phone and email and snail mail. So I was introduced to her through a shelter worker, and she was in the Roanoke area, and basically they had an intern there who was interested in helping her with this. So the intern and I would communicate, and this was a woman who was from China, and at the time her English was very limited. So we had to use language lines to communicate directly. So this intern was pulling together all of these documents that prove these different elements and would send them to me. And then I'd say, this is weak, and this is why it's weak, and I need more, and I need this, and here's an example of what I need. And we'd go back and forth like that. With this particular client, so she left literally with the clothes on her back. Her husband had burned her passport, all of her documents, she had nothing. She did, however, and I think she had to actually file to get copies, ask USCIS for copies. So what's supposed to happen, let's say I'm not married, I'm a US citizen, and I want to marry a foreigner. What is supposed to happen is I apply for that foreigner's fiancé visa, and then there's this, it's called the I-130 Petition for Alien Relative. So it's me sponsoring, me as the US citizen, sponsoring my foreigner husband. What's supposed to happen is I'm supposed to do all that, and then he would get what's called conditional residence. It's like a 2-year green card. And at the end of that 2 years, there would be a review to see, is this a fraudulent marriage? Is it a good faith marriage? Let's remove if it's seen as a good faith marriage, they remove the conditions and he gets his full green card. And the green card, by the way, the status lasts forever, but the card expires every 10 years. So people have to stay on top of renewing that. Or if they want to and they're eligible, applying for US citizenship. So in her case, we didn't have any proof of, we didn't have access to even her stuff, but we didn't have access to his passport. You know, what she had was this petition for alien relative that he originally did and then let go. He didn't follow through with it, where he signed and said, I was born in Pulaski County, and, you know, so proving that he's a US citizen, that's what we sent in to prove his status. And it's the federal government, they can do their cross-checks and do their cross-checks to figure out and verify. So that's how we were able to prove that element. Good faith marriage, as I said, it's been under more scrutiny lately, so you definitely want to submit the marriage certificate if you can get your hands on that. But wedding photos, this client I mentioned that I'm concerned about, she had nothing. You know, nowadays everything is digital. That's kind of the, you know, a lot of stuff is digital. You have your digital photos online, and maybe it's your friend's album. You don't actually have the album. So she never could get her hands on actual pictures, but for one that showed them at like an amusement park together. But nothing from the wedding, nothing from the reception. These were all deleted by her friends, and she didn't have any of that. But those are the types of things that can prove good faith marriage. Letters and cards and emails between the partners, etc. Shared residence, a lease, court documents, tax returns, and then getting to your question about how you prove the abuse. So it could be, for the Volatile Petition, as I said before, you don't have to have a criminal case or any court case to prove it, but police reports help, medical records, photographs of injuries. I usually try to take color photographs or copies of the photographs of the injuries, protective order paperwork, and then of course you're going to have the person's affidavit. Usually I've met clients through a shelter, a local program. So she's already working with an advocate. I'd have an advocate, a licensed social worker, or an advocate sign a document saying, I've been working with, I have had 15 years of experience working with domestic and sexual violence victims. Ms. Jones presented herself and we started working on da-da-da-da. That's the kind of affidavit I'm talking about. Supporting letters, that kind of thing. I had a really amazing case. This was a client, a Volatile petitioner. She was married, is still married, to a green card holder so he's the green card holder. He's the person that's allowed to be here legally and work here, etc. She's completely undocumented because her visa, which I believe was a fiance visa, expired long before. Not only did he not sponsor her, but he would put her out to work under the table for the family. That was the only income for the entire family. He would drive her to the bus. She had to get on the bus. She'd go take 2 buses to get downtown to work at a restaurant. This is in Richmond. Work under the table and then get on the right bus home to meet him to hand all the money over to him. That was their relationship. And she, on a break, went to the library and found out about me and my clinic. Long story short, how we worked together is she would come for 10 minutes before she had to pick up her bus, because she had to be at the right bus, like the timing was important, otherwise she was accused of having an affair or this or that, right? So she would literally, what we do is, I'd say, you just come, you don't need an appointment, you just come. If I'm here, we talk. If I'm not, we don't, and you can leave notes for me in my mailbox. And she was able to email me because she was able to, on her breaks, go to the computer, and he never used a computer. So that was very helpful for her. For a year we worked like that, pulling together. Keep in mind, all of these, 1, 2, 3, 7 elements of this Volatile petition. We worked like that for a year, okay? And we sent it in, and I had to meet her like at a Martin's. She had to, lie to her husband, oh, I'm just going for a walk, I want to get this, those free newspapers from the grocery store. We met, like, clandestinely, I'm filling this stuff out, having her sign forms, send it in. What we got back was a request for more evidence, RFE. It comes in a blue sheet, and you can see it through the window of the envelopes. You're like, oh. They didn't quite make it, you have to come up with more additional evidence. So in her situation, they needed more evidence of the abuse. She comes from a country, she's actually from Sudan, and she had gotten asylum from all of the war and what was happening in Sudan in another country, and then came, so she's a citizen of that country, and then came to the United States, having married her husband, etc., fallen in love with him. So she comes from a culture where it's very difficult to express these types of intimate details of, we're talking rape and, physical injury, emotional abuse, and isolation. So they need more evidence of that abuse. And what we ended up doing is she submitted a supplemental affidavit, and she got her husband's brother's wife. So for all intents and purposes, someone who owes allegiance to her husband's family, to write, yes, I did see her on these occasions being da-da-da-da, she was, in my opinion, she was a victim of domestic violence at her husband's hands and wasn't able to do anything about it. So we did finally get her Volatile petition, and we're doing her green card application right now. So, think about that. 10 minutes a day, every so often. She's hoping I'll be there. And then she has to run for the bus. So one time, this was quite terrifying, because we ended up talking too long to a hotline worker to try to figure out if we could get her and her kids into shelter. So we missed our timing deadline to get her to the bus. So I put her in my car, and we drove along the bus route to catch the bus so she'd make her transfer so no one knew anything. I mean, this is the kind of thing you have to end up doing. Anyway, so that's the Volatile petitioner. Keep my eye on the time. As I said, good faith marriage can be a hard thing to prove. It's the person's, though it's the victim's, the petitioner's subjective belief that they were married in good faith. So, for example, where the husband is a bigamist and is married several people, right? That's a void marriage in Virginia. But if she believed that it was a good faith marriage, and in her culture, a man takes more than one wife, it would be, she'd have to explain that, but it would be considered a good faith marriage. So, what's beneficial about these is that, one, she would get legal status, and she can apply for employment authorization. She can get a work card, be able to work here, and then at some point be able to apply for a green card. All right, so I know it's late, and you guys, this is dry stuff. I'm talking about things that might be hard to apply. But do you guys have questions right now about this? And it's the kind of thing that you have to be really immersed in to understand the significance of working with a client, filling out these forms to understand how they work. But do you have questions right now? Yes?
If there were an instance where a client could potentially become subject to deportation,
Right.
because there is some discretion involved, I mean, could
Right.
like you make a phone call and
I
say,
can't
hey,
I don't have that kind of power, I wish I did, but, but what we could do is put together one of these applications.
and
If
get
we think they're,
started with it.
yes, and
Mhm.
that's an awesome question and a good segue into the U visa section, because I have a client who, she's actually in deportation proceedings. She's not in detention, you know, she's not in a prison, but she's supposed to be deported to her country of origin. So she came to my attention actually through a police department who had interviewed her and determined that, you know, they thought she might be eligible for a U visa, brought it to my attention. We put together real quick this U visa application. So that's pending now. It's still pending,
Right.
but that can kind of slow the process down.
Okay.
Because now what she's supposed to do is go check in with ICE in DC every month or so. So the last couple times she's given them my number and my card and said, so she was doing this for me.
They're
And
aware of what's going on.
yes, exactly. And that having once, and she does, I think she's going to get, I can't guarantee that she's going to get approved, but I believe she will be approved for her U visa. Once that happens, that will stop the deportation process. Yeah.
How long does this last?
Good question. So the Volatile petition, that lasts basically for 15 months. You can file to extend it, which I've had to do because the person wasn't yet eligible to apply for their green card, because there's such a glut, right, of cases in the pipeline, and the United States government gives priorities to certain types of petitions. So, for example, if you've been here longer and you're from certain countries, you'll get this. Everybody gets this priority date, and that priority date appears on your correspondence from the federal government. So this client I mentioned from Sudan originally, so she got her Volatile petition. Great. You know, she has it for 15 months and she can apply for work authorization, but she wasn't going to be able to apply for her green card until after the Volatile petition expired. So we had to, in a timely way, file to extend the Volatile petition, which we were able to get. So that's what she's operating under right now, the extension.
So how long is the extension?
Another 15 months, and then, you know, in the meantime, once I apply for her green card, if she's approved, then she has the green card and she's here. That's an indefinite status. She doesn't need a work card. She'll be able to work with that. You know, she'll be set basically. And just as an aside, at some point in the future after that, she'll be able to apply for her U.S. citizenship if that's what she wants to do. She has 2 U.S. citizen kids. But given that I work for low-income people, vulnerable people, and it's just me, really. I don't have any help. I don't have a secretary. I don't do the U.S. citizenship applications because I figure at that point they've gotten a green card. They're here legally for an indefinite period of time. If they want to get their citizenship, good for them, but they can get somebody else to help them with that. So that's how I'm looking at it. I'm here for vulnerable people. So that's the answer to that question. There are no fees for the VAWA self-petition. Some of these immigration visas, by the way, are super expensive, like the green card application by itself, and it needs a bunch of other applications, is $985. That's a lot of money for most people, even people who are not low income. So I file fee waivers with all of my visa applications that require fees, but even that's kind of a pain, like you're pulling together all this documentation of any kind of public benefits they've received, even on behalf of their children. I mean, it can take a long time to pull that stuff together, so that's delaying the process of applying too. But the VAWA self-petition is free. It's an emergency type of visa application. You're saying, I have to petition for myself because my U.S. citizen husband or green card holding husband has been abusive to me and is not sponsoring me. All right, moving along. I'm going to skip over this because this is more about public benefits. Let me talk about this quickly because I really want to talk about the U visa. So remember I mentioned an example, like if I'm the U.S. citizen marrying a foreigner husband, you know, I'm sponsoring him, he gets this conditional residence, like a 2-year green card. Some of our clients have that 2-year green card. It's called conditional permanent residence, and they are victims of domestic violence, and their abusive spouse is not doing what he needs to do to schedule the interview to have the conditions removed so she could have the victim can have that full lawful permanent residence green card status. So that's kind of like VAWA self-petition light. It's called the battered spouse waiver. So you're proving some of the same elements that the abuse happened and that you had good faith marriage, but you don't have to prove all those other things, joint residence, etc. So you're really proving those things in order to have the condition removed so you can get your green card. All right, and that's the I-751 form.